Good evening. My name is Juan Zavala. I'm Vice President for University Advancement at Lamar University, and it's my pleasure to welcome you to the Digital Alumni and Friends Gathering. With social distancing being the norm, we've decided that the way for our larger community to stay together at this time is to come together every Tuesday night for a gathering of our alumni and friends. And at these gatherings, we ask one of our distinguished alumni to come to us and talk about an area of interest in their field. You've tuned in a great night. You have a tremendous opportunity tonight to hear from the Honorable Hyattye Simmons. Hyattye got his bachelor's degree in government from Lamar University, summa cum laude, in 1979, and then went on to get his law degree from the University of Texas School of Law. During law school, he was a clerk at the Texas Attorney General's office and also clerked for the General Counsel of the Texas Secretary of State, and later as full-time legal assistant. At the age of 26, Hyattye was appointed General Counsel by Texas Secretary of State Myra McDaniel. After his service for the state of Texas, he moved to Dallas, where he became Assistant City Attorney for the city of Dallas. And then from there, he went to work for the Dallas Area Rapid Transit, DART. And he had a 24-year career there, ending as General Counsel. During that time, he received the Magna Stella Award for Excellence in Leadership and Management for nonprofit and government agencies from the Texas General Counsel Forum. And during that time, he was named Distinguished Alumnus of Lamar University. He now, after his retirement, in his new career, Hyattye has become Associate Municipal Judge for the City of Seagoville, Presiding Judge for the Municipal Court in the City of Combine, and in his spare time, he is General Counsel for the North Texas chapter of InfoGuard, which is a part of the National Alliance between the FBI and the private sector. Hyattye, welcome. It's great to have you here.
Thank you. It's great to be here. I just want to thank you, Lamar University, for inviting me on. And I hope we have a very good presentation tonight with lots of questions.
Excellent. Right. Before you get into your presentation, Hyattye, just a little bit, take a moment to walk us through. You accomplished a lot, and you're actually very young still, and you've accomplished so much in your career. From working for the state government, and then for corporate, it's kind of like corporate counsel, really, even though it was a government entity, and now in the judicial process. So give us a little feel for how your career evolved and who was in place to help you along your way.
Well, my career actually began with my eldest brother, who encouraged me at the ripe old age of 7 to have a career in the first place. And then when my mother moved back to Texas after his death, it was going back to being able to go undergraduate and go to grade school, junior high, high school with people who were still teaching that taught my mother. Back then, education was a career, not just a job. And so their feeling was that if they could get up and walk, they were going to go teach. And so that was a real treat. And so, and then Lamar University was instrumental because I remember the first summer at Lamar when I thought I was graduating from my high school. I said, I know everything. And I remember the English professor saying, you come in thinking you know how to write. When you finish this class, you will know how to write. And she was correct. I got that first grade back. I said, I don't know how to write. So Lamar University has been very instrumental and pushed me forward. And then it was just a matter of working hard and being in the right place at the right time. So it's really been a great experience, and I look forward to more additional years on the bench.
Oh, well, thank you. And speaking of the bench, now in your almost like third career in your legal profession, now you're the Honorable Judge Hyattye Simmons. And so you agreed to talk to us a little bit about resilience in the court system during this time. So Hyattye, we'll turn it over to you for that presentation.
Thank you. Mr. McGee, would you please give me the next page, please? Oh, thank you. Now, what would a legal presentation be without a caveat? So the information I'm giving here is educational and information only. Lamar University has control of it, and anything I say is my opinion only. I'm a sitting judge, so the rules of judicial conduct. I can't be speaking on behalf of my court or any part of state government. So, next page, please. Okay, before we get into how resilient our court system was, we really need to first understand the size and scope and the complexity of the court system, both nationally and in Texas. Once you understand that, then I think, like myself, would be amazed about what was done in a short period of time. Next slide, please. Okay, so as always, we start with the U.S. Constitution. It's the 10th Amendment to the Constitution that the power is now delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively, or to the people. And so, next slide, please. So what that meant was that each state has its own right to create their own laws, their own court system. They're only limited by the U.S. Constitution or any federal law that's been passed that's preempted the area, where it says no states you can't write any laws or anything that goes through this area will go through our courts. But still, so what it's surprising. I get well-educated individuals who don't understand that, yes, there's one federal system, the United States of America, but there are 50 sovereign entities within that, each of them with their own flavor of laws. Now, all of them are similar, and we can go through, it would take forever to go through all the similarities and dissimilarities. Matter of fact, if we spoke on this one page for the next 10 years, we wouldn't be able to cover all the nuances of when the Constitution comes in and says states you can't do that, when the federal government says no, we preempt you from doing that. It is an incredibly complex area. But you don't need to know that for tonight's presentation. All you need to know is that states can make their own laws, states can have their own courts, and the only limitation they have on that is the U.S. Constitution and possibly federal law. So, next slide, please. Okay, so let's talk about Texas. Let's talk about our Texas Constitution, which, by man, I must add, is one of the most amended constitutions in the country. But it's Article 5, Section 1, and it says the judicial power of the state shall be vested in the Supreme Court, in one court of criminal appeals, in the Court of Appeals, and district courts. Next slide, please. In county courts, in commissioner courts, in courts of justice of the peace, and such other courts as may be prescribed by law. The legislature may establish such other courts as it deems necessary. Okay, so what is the court system presently? Does this presently in Texas? Next slide, please. Okay, hopefully you can see it, but I'll talk you through it. At the bottom, you have the justice of peace courts and municipal courts. All these courts are important. It's just that the way this is laid out, the courts that are the ones closest to people are the ones are the easiest for a layperson to be able to go in and get things done. So as you move up the chain, it becomes the procedures for presenting a case and presenting your arguments and presenting your matters become more formalized. So most people in Texas will go to a justice of peace court or a municipal court before they go to any of the courts above this. And I serve as a municipal court judge there, and my duties are a little bit different in that while most of my things I deal with Class C misdemeanors, and let me explain something. In Texas, you have misdemeanors and felonies. And the only big difference is that misdemeanors, you got two types. Misdemeanors are generally crimes that are punishable by less than a year imprisonment. And then of those, you got three types. You got Class A, Class B, and Class C. Class C are those ones punishable by fines. And a B is by incarceration no more than 6 months, and then A is up to a year. But in my situation, as a municipal judge, I typically hear in court Class C misdemeanors and other city violations like ordinances. Like the person dumped, violated a building permit, something like that. But all judges in Texas also have a dual capacity, and as a magistrate. As a magistrate, your powers are to issue search warrants, arrest warrants, and to do what's called arraignment, where basically you can, at the person's been arrested, they have, typically in Texas, in our area, we have 24 hours to bring them before a judge, read them their rights, and then advise them of what their rights are. Constitutional rights is laid out by the U.S. Supreme Court. And then we set a reasonable bail for the crimes that they alleged to have committed. So anyway, above the justice peace courts and municipal courts, you have county courts of law. There used to be a big difference between county courts and the next court we're going to go to in a minute, but that was taken care of. It's really there's only a few statutory things different about county court law than a district court. So let's go on to the next slide, please. Okay, after you get past the county court level, you then go up to district courts, and then everything from the district courts, county courts of law, municipal courts, and JP courts, I call trial courts because those are where people actually go in, and there's procedures for putting on evidence, listening to witnesses, judges make the rulings. When you get to these higher courts, they're not putting on a trial. They're just hearing what happened in the lower courts below, and they're going to make a decision on whether or not that lower court decision was correct or not. So anything above the Court of Appeals to Supreme Court, Court of Criminal Appeals are appellate courts. And in Texas, while you may have both civil and criminal matters in the courts below, once they get up past the Court of Appeals, they bifurcate. All criminal appeals go up to the Court of Criminal Appeals. All civil cases go up to the Supreme Court. And the difference between civil and criminal is that is the same. In criminal cases, you're talking about taking away someone's freedom, whether it be 6 months or whatever. You're talking about taking away someone's freedom. And I forgot to mention that felony is punishable by more than a year. On the civil side, it's usually about money. It's about money or some other legal remedy that does not require someone actually going to jail. So let's go on to the next page, please. So one thing I wanted to mention too is that there is sometimes confusion between Court of Appeals and administrative regions. Let me explain something. Again, Courts of Appeals are those regions, those courts that hear a protest about a decision in a lower court. So if you got a decision in the district court, county court, then and you want to say that's wrong, I want to take it up, you would go to one of these 14 districts, depending upon where the court resides. You would go to the Court of Appeals in that area, but they don't do any real administration. They basically hear cases of law and make a decision on what is proper or not. Next slide, please. This is different than administrative judicial regions. These are people who take the orders from the Supreme Court and Court of Criminal Appeals and see that they carried out. Here I give you a little information about them. These are guys who've been experienced judges. They're appointed by the governor for 4-year terms. And if you go to the next slide. Okay, and their whole job in administrative reasons is to make sure that the rules for administration of what goes on in that region are carried out. So if the Supreme Court and the Court of Criminal Appeals issue an order about how they want the courts in Texas to behave, these people, along with the Office of Court Administration, make sure those rules are carried out at the local level. Okay, next slide. And this will become important later on when we get to some of the actual orders that were issued by the Supreme Court and the Court of Criminal Appeals. So this is summarized, and this book is actually available online. You can go pull it up and read about your courts. But basically, we're looking at trial courts. We're looking at 3,100 trial courts. Those are the ones that actually try the cases. We're not talking about appellate courts. We've got 27, 2,744 judges. Now you think, well, hold it, we got 31 courts. We got we got judges and we got courts. So there seem to be more judges than courts, and that's because missile judges have the power to be judge in more than one jurisdiction. So just like I am a judge in two jurisdictions, missile judges are only judges that can do that. And the reason is that this is, if you remember back in the old days when, well, the old John Wayne movies, when John Wayne would be saying he's got to wait for that circuit judge to show up so he could get justice done. Well, and then basically back then you would have a judge that would rotate, go from city to town and hear cases and make decisions. Well, see, the missile judge is the modern day version of that circuit judge. We can be in multiple jurisdictions. The city just appoints us as a judge for that jurisdiction, and we can do that as many jurisdictions as we'd like to handle us. But we're the only ones. We're the only judge that can do that. So that's why you have more judges than courts there, because you got multiple judges doing service in a lot of in a lot of towns across the state of Texas. But the big kicker is this: even though with these numbers, 3,100 judges, they're serving 29 million people in the state of Texas, spread unevenly across 254 counties. So even though we've got 3,100 judges, that is a lot of people to service in a state this size. And the quote from this report says the Texas courts closed out the end of a busy year. They had 9 million cases filed last year, and they disposed of 8.9 million of those cases. So they had an existing docket. They got 9 million more cases added to the existing docket, and they cleared 8.9 million cases. So it was a very busy year for Texas courts. And then I make a point about JPs and missile courts judges. They often serve as what's called, as I said before, Texas magistrates. And here I put a number of 948,000 magistrate warnings. Those are the warnings I talked about earlier, where a person is arrested, and this is one thing that separates our justice in this country and this state from anywhere else in the world. In some places around the world, you can be arrested, never know what you were charged with, never told what your rights were, and you basically sit there as long as they want you to. In this country, that's not the case. And the reason why I serve, we've got 24 hours if that person is arrested to have him be brought for a judge. We inform him what he was charged with, and then we read him his rights. Now, one thing about this number is not equated to the actual number of persons that were brought in for that, because sometimes you will have people coming in with multiple charges. They will have a Class C misdemeanor. They will have a Class B, a Class A. They may even have a felony. So more times than not, you'll have people with multiple offenses but still 948,000 warnings were given last year. Okay, next page, please. Okay, so now we get down. Now we know the size of the scope of Texas's judicial system. We can get into some of the facts about how the resiliency took place. And this is important. There was some prep work done, because back in 2008, the Texas Supreme Court established the task force to ensure judicial readiness in times of emergencies. That's important, so they went ahead and we don't know what's coming in the future. There could be anything, but we want to have a plan that helps us manage this court system across all 254 counties and all 2,700 courts. And in addition, in 2012 and 2014, the Texas Supreme Court and then the Court of Criminal Appeals require attorneys to use electronic filing. We stopped using paper and went electronic. That will be important later on. So going into the facts of this case, with regard to the COVID-19 issue, we have March 13th of this year. Government evidence issues a state of emergency, a declaration of emergency with regard to COVID-19. There is a statutes that give the governor certain powers to do things when that happens. On the same day, the Texas Supreme Court and the Court of Criminal Appeals. Now I say, why do we need two courts? Because remember, the Texas Supreme Court governs all civil cases, Court of Criminal Appeals governs all criminal cases, criminal courts and criminal judges. So you needed both of them to issue a joint order for it to be applied to all courts across the state of Texas. So they issued an order, and the main thing about that order was that, subject to the constitutional limits, they wanted you to take steps to avoid getting any court staff, parties, attorneys, anybody that comes in the courtroom infected with this virus, and that you should start using video conferencing or teleconferencing to conduct your non-essential hearings. Next slide, please. Okay, so on March 18th, both the Texas Supreme Court and the Court of Criminal Appeals issued a second joint order. Now, let me say something. The Supreme Court issued a bunch of orders. Hang on a second, let me bring a better slide here. Yeah. Issued a bunch of orders, but these are two joint orders that both courts issued that got all courts in the state of Texas. And this one here, they came back and said, okay, look, we're going to prohibit non-essential proceedings, and that takes the essential proceedings would be like essential proceedings. Get a little feedback. Okay. Let me turn my.
All right.
Okay, are we good?
Yeah, sounds good.
All right. I think I lost my screen. Anyway, let me continue on. Non-essential hearings meant those things that could be done either by video conferencing or see if I'm here. I'm getting a little bit of feedback. Turn this down a little bit more. All right. Yeah, that could be done without in-person proceeding, and so what they wanted to do was move those over to video conferencing and teleconferencing type proceedings. Now, with regard to arraignments, where people has got to be advised of their rights, those were deemed to be critical, essential proceedings if the entity did not have the ability to do a video conferencing. So those continued on. Then to help the courts do the video conferencing, every judge in the state of Texas was presented with their own video conferencing account, and they were given training on how to use it. And then after that, they started postponing jury trials and other non-essential matters were done for conferencing. And let me explain something here. Jury trials were not canceled; they were just postponed until later on in the year, to when the rules against social distancing were relaxed. Next page, please. Okay, so the conclusion is this, and this is just my opinion. The previous work by the done before 2019 really set the courts up to continue to do operation, because the courts have not closed. The physical buildings have closed, but the courts are still in business. They're still, handling criminal cases. We're still having civil cases, but it's done electronically. And the real kicker here, the real thing that I really want to emphasize is how much the prep work did to help make this possible. And the main thing that I want to emphasize is electronic filing that was done by 2014. And because if you realize the state of Texas became its own nation in 1836, the Supreme Court, the Texas Supreme Court, was established in 1836, but didn't have his first hearing until 1840. But still, from 1840 to 2012 or 2014, you're talking about over 170 years. So for over 170 years, the traditional way of doing work with the courts was by paper documents, tangible documents. When the electronic procedures were passed by the Supreme Court and the Court of Criminal Appeals, that took away that. So since most of my career was during the paper era, so to speak, I can speak that there was thousands of people who were handling those court cases, handling those documents. You had file clerks in your office. You had file clerks at the courthouse. You had mail people who had to deliver the stuff you mailed to the court to be filed. It was a whole industry of people just to move mountains of paper, and all that went away by 2014. If that hadn't happened, I don't know. I don't think this transition would have been as successful, because we now know this virus can live on surfaces for any amount of days or hours. And so, if you get this paper being transferred from person to person, you're increasing the risk of the virus going along with it. So, by limiting that, you eliminate all the needs for individual people to be at the courthouse, for anyone to go down to the courthouse. You can get the access to your files online. You can, if you need to file a document, you can file that electronically. Every attorney in the state of Texas, all 125,000 of us, must have a email address. And so it really did a lot of the heavy lifting. And plus, the Supreme Court went through the trouble of modernizing the courts in all 254 counties. So by the time this issue came along, most courts and most judges were familiar with electronic medium in one form or another. So it really helped out with the resiliency of the court system. So last slide, please. And that concludes my presentation. And now I turn it over to questions and answers.
All right. Thank you so much, Hyatye, and we appreciate your patience as we navigate through this new methodology we have for social gathering. But during the discussion, we have had a couple of questions. Vernon has a question to sort of follow up on your discussion about moving to electronic systems in 2014. But how has this pandemic then and the social distancing affected other processes within the court system, or the nuanced processes that still go on in the court systems?
Well, I mean, everything. The others have been unaffected. For example, for serving of lawsuits, they passed a rule saying that on the civil side, that those could be served by social media. So if you know someone has a social media account, you can serve them a subpoena or a lawsuit through that social media account. I mean, they tried to move everything they could over to electronic means. Wow. So now depositions can be handled by video conferencing. Mediations can be handled by video conferencing. If you need a court hearing to talk about a dispute, you can have that by video conferencing. So it really, once you got rid of the paper, everything else fit nicely into the current technology.
Right. All right. So now, stepping back a little earlier than 2014, Tim wanted to know what brought on the need to create the establishment of the 2008 provisions.
Well, it was just a foresight by the Supreme Court of what was going to happen with future technology in society, and the idea that the courts, after 170 years of doing things one way, need to improve. And the one thing I can point to is actions by our Texas legislature, because in 2007, the Texas legislature passed the Uniform Electronic Transaction Act. The federal government did a similar act nationally, but the the state also had the option to pass their own statute, and what that statute did was that um, uh, it it made electronic documents have the same effect as a tangible paper document, and that was critical. It made electronic signatures have the same effect as a handwritten signature. So I mean, so that was laid the ground the foundation for the court to come in 2008 and say, well, 2012 and say, hey, we need to do something with this technology. And as far as 2008, when they set up that committee, it was just the forward-working thinking, and the statute probably was the impetus that drove it on. And we think about, let me pass on something else. Let's go back further to 9/11, when the two towers fell. They destroyed buildings in and around them. One of those buildings was the court for that portion of New York, um, and the building was totally demolished. 3 days after the destruction of that building, that federal building, the attorneys who practiced law in that bankruptcy building were given a link to where they could go and look at their documents. Why? Because that court had gone electronic years before. And I think courts around the country took notice of that in the most unfortunate, unforeseen circumstances, the courts were resilient to keep on working. And so I think all that played a part in 2008 in the Supreme Court going and looking at getting an emergency plan, and then also ultimately leading the state to electronic filings.
Excellent. And to sort of follow up on that, I'm skipping around the questions here now out of order, but Jeff, who is watching, he wants to know what effect then these changes we've had because of the pandemic have had on time-sensitive legal obligations, considerations like statutes of limitations or the right to a speedy trial.
Well, in those orders, the Supreme Court on the civil side suspended or extended statute of limitations.
Okay.
So all those were extended to like 30 days after the expiration of the governor's state of emergency. And also to give the power to local courts to change any deadlines necessary to help with the justice of that case. The speed trial thing doesn't come in play because remember, speed trial was for a limitation on the executive branch of government to be able to prosecute the individual, and they had to be ready by a certain time. This delay was not done by the executive branch; it was done by the judicial branch, and so those deadlines don't come into play.
All right. Well, and we've had a couple of questions come in from prior parts of your career, but let's stick right now for the judicial system and move to those in a minute. But you mentioned in your slides that there were 8.9 million cases disposed by Texas courts in the last year, in 2019, an extraordinarily productive year. That takes more than lawyers and judges to accomplish. And you talked a little bit about people who work in the court system to process paperwork. Now it's changed a little. So what other areas of the law can a person get into to be still involved in the judicial process without being a judge?
Well, you can be a clerk. I mean, there's various levels of clerks in the courts. There's court administrators. On the criminal side, they have investigators. I mean, there's not as many positions as there were back in the days of the paper, because they really don't have that great need for file clerks as they used to have. But still, there's still other non-judicial positions that are still needed in the court system.
Excellent. And then to follow up on the question that Jeff had asked earlier, you talked about the speedy trial and the other. Vernon has followed up with a question to see if you have heard or if there's any discussions out about other things like early releases or maybe non-detaining for certain crimes that are being considered by the judicial system at this point?
Well, all I know is that the governor issued, on the state of emergency, the governor has the power to suspend certain laws. So he suspended laws for expiration of driver's license and certain other minor offenses. So if those laws are suspended, then there's no reason for someone to be picked up for those offenses.
Okay.
But that's about it.
Excellent. And then going back, Hyatty, to something that you and I share in common, which is a real connection with the students, especially the students at Lamar University. One of our viewers, Shannon, asks what advice you have for aspiring lawyers, for students who are in undergraduate or law school who have an interest in going into the public service part of the practice.
Well, I mean, the best thing is to try and clerk. I mean, go find a law firm. I mean, you may have to work there for free, but hopefully they'll pay the minimum wage. But let's say you want to learn that you're a person who's interested in law and you want to work in a law firm and start learning. I mean, most firms might tell you no, but sooner or later someone will tell you yes. Um, it'd be nice if there was a program out there that would help fund that. But still, the big thing is you get to learn the law by doing it. And my main thing is try and take the courses that are going to help you write. Writing is important. Reading is important. Comprehension is important. I mean, it doesn't matter if you're an electrical engineer or English major. I mean, reading, writing, and arithmetic is still important.
All right. Well, and following up on that a little bit, you in your biography, we mentioned some of the obstacles that you encountered along the way and that you just overcame by your diligence. One of the new ones that I had not heard about until tonight's presentation was your sort of confession early on that writing may not have been one of your strong points at the beginning. And what we know about you is you're an extraordinary writer now. So other than taking good writing classes, how else does a person hone their writing skills?
Practice, 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 and practice, and more practice. I mean, that's all I can say. I mean, even as a lawyer, a beginning lawyer, it took me a while to get to hone my craft. This is a, a, a art, not a science. And as an art, you become better at it the more you practice it. And so the only thing I can say is this practice makes perfect. And now I'm still learning different nuances that will help improve my practice.
Right. Well, and another part, following up on with students, and again, something that you have been involved with Lamar since its inception, maybe 15 years ago, was programs we have to help students who arrive in college with less of a support structure at home to accomplish these because they don't have somebody to go back to. So what would you advise to a young student, an undergraduate student at Lamar University who's sort of facing this broad, expansive opportunities on their own? How can they reach out to people like Judge Hyattye Simmons to get guidance or advice?
Well, I would start with the local bar association. I mean, every county has a bar association, and they may have mentoring programs already set up. So I would start with them. There are also various organizations around the state, but the state bar of Texas has a paralegal section that will give you information on how to start studying to be a paralegal. Is just someone who helps the lawyer do their work, and there are courses out there and materials out there you can learn that will teach you more about the practice of law. But the main thing is to reach out to people. Don't be afraid to ask, and people will, and that's how I got started. And I think the same thing will work for anyone.
Okay, excellent, thank you. And now, Karen, who's one of our viewers, mentions that you have quite a number of successes in your career. You've accomplished a lot of things, but can you identify maybe what you feel maybe your greatest professional accomplishment?
Wow, that would have to be my winning my first oral argument for the Texas Supreme Court back in 2003. Um, at the time, it was an important decision for my agency. But after I argued and won it, it went on to have a life of its own because the rule of law that I was able to get the Texas Supreme Court to adopt in that case went on to be cited in hundreds of cases subsequently, and it's really become one of the cornerstone cases if you want to know about government liability in the state of Texas. So that's the one I'm most proud about.
Yeah, excellent. And to follow up on previous discussions we've had on how the court systems have adjusted, Shannon, who's watching, asks if you have success stories from employee staff of the court system who have adapted their own processes to be able to support judges to do their job.
I, I don't know. I think the court staff have been pretty resilient. It's like I've been working with my uh, my chief court administrator today on doing plans for reopening our courts, and so I mean, a judge cannot run the court by himself. He has to rely upon good staff, and the staff that I've been working with has been even through this difficult time. They've been there whenever I need them for assistance. So they've been very, 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 very good and very effective.
And just maybe to close up, I've got one more question. I don't see any more coming up, Hyatty, but going back to the 8.9 million cases closed last year, again, an extraordinary number. This year, that number may not be met, right? But 9 million cases coming in. Do you see
Well, I know that the judicial. Well, let me explain something how courts work. Usually, when you're in a criminal or civil case, there'll be a docket, and the court will schedule the cases from oldest to newest on as many as they can squeeze in on that docket, and then they'll call the cases up one at a time and see how they want to handle if the matter is going to go to trial or if there's going to be some hearing needed to handle. Um, those things have been postponed. So, but I don't know if that's going to affect the actual number of cases closed of this year. We'll have to wait and see what the final tallies are. But I think that the main thing is that while those in-person dockets aren't happening right now, the work is still being done behind the scenes. And so anybody who needs to get access to a judge or a court can do so. And all you got to do is just send a notice to the court saying, hey, I filed a document, I need a hearing, and the judge arranges to set a date. And that's still happening. So justice in this country, we take our constitutional and state responsibilities for the justice system very seriously, and we're doing everything we can to keep it open.
Beautiful. And Hyatty, I think that's the perfect capstone to this discussion. I want to thank you again for taking the time to visit with us. And in the last decade and a half, I keep saying I owe you, so I guess I owe you more. You're a good friend to your alma mater, and we appreciate your taking the time to visit with us. To close out this segment, we have our marketing team, Daniel and Kevin, who Hyatty and I have been watching in the background doing all the work here for us tonight. We'll close out the program with a video that they have prepared for this. I did want to tell our viewers that if you have a question for the judge later as you watch this video, if you want to go ahead and contact us, we will direct those questions to the Honorable Hyattye Simmons. Hyatty, thank you. You're a good friend to Lamar, and we appreciate your time.
I appreciate it, and thanks for the invite.
You betcha. All right. Thank y'all.
I want to help people.
I want to be a part of the solutions of tomorrow.
I want to bring innovations in times of need.
I want to turn my passion for helping others into action.
I want to be the voice that shares truth with the world.
In times of uncertainty, being a nurse is how I will make a difference.
My professors have taught me human resources is about putting people first.
Through the power of mechanical engineering, I've learned how to better the world around me.
Because of Lamar University, I've been given the opportunity to change my world.
To change our world.
Our moment is here.
Our moment is now.
Make the most of it at Lamar University.